Appearance.
May it please this honorable court. My lord, my name is Ozinko.
Yes.
Our humble appearance is for the claim.
Yes, any other appearance?
With profound respect, my lord, I appear
Yes.
for the first defendant. I am Gideon Onwok.
Yes, any other appearance?
Yes, my lord, probably, my lord. My name is Barrister I. My appearance is for the second defendant.
Any other appearance?
No, my lord.
Yes, this matter is for judgment. The judgment of the court is ready. This is the judgment of the court. On the 11th day of November 2025, parties adopted their final written addresses, and the court adjourned the matter for judgment and informed counsel that the date for judgment will be communicated. The judgment of the court is ready. When the judgment of the court was ready, I ordered the registrar to notify the parties that the judgment will be delivered today. The originating process commencing this suit was filed on the 4th day of July 2019 by the claimant against the defendant. The complaint was accompanied by a statement of facts, witness statement on oath, list of witnesses, list of documents to be relied on, and photocopies of documents to be tendered as exhibit. On the 23rd day of October 2023, leave was granted to the claimant to amend his complaint and deemed the amended processes already filed before the court on the 19th day of June 2023 as properly filed and served. By the amended complaint, the claimant, as per amended statement of facts, sought for the reliefs as follows. 1. An order of court ordering the payment of claimant's contributory pension funds in the custody of the defendants to the claimant. 2. An order of court that the total sum of 1,679,000 naira, only being the claimant's retirement savings, be paid to the claimant. 3. General damages in the sum of 50 million naira to be paid jointly and separately by the defendants for the injuries suffered by the claimant as a result of the defendant's act, conduct, and omission. 4. A declaration of court that the claimant is entitled to his contributory pension fund as agreed. 5. Cost of action. Upon being served with the originating process commencing the suit, the first and second defendant filed their respective statement of defense. On the 29th day of November 2023, the claimant testified in proof of his case as CW1. Documents were tendered through CW1. They were admitted in evidence and marked as Exhibit A to L. One Kingsley, a branch manager of the second defendant, led by IA Inyang Esquire, testified in chief as DW1 in defense of the second defendant. DW1 adopted his witness statement on oath as his evidence in this case. DW1 tendered documents which were admitted in evidence and marked as Exhibit DWA to DWE. DW1 was cross-examined by counsel for the claimant and counsel for the first defendant thereafter he was discharged. The first defendant called one Robert Antiga, one of its staff, to testify in defense of the first defendant as DW2. DW2 adopted his witness statement on oath in this case. DW2 did not tender any evidence. He was cross-examined by counsel for the claimant and that of the second defendant. Thereafter, he was discharged. The third and fourth defendant did not defend this matter as they failed or refused to enter appearance or file any defense. The case of the claimant, I will skip reading the case of the claimant. I will also skip reading the case of the first defendant. I will also skip reading the case of the second defendant. Then the shared in the body of the act of the judgment. I go to the submissions of the second defendant, wherein 3 issues were formulated. The argument of counsel have been captured in the body of the judgment. I also skip reading it. Then the submissions of the claimant, who nominated only one issue for determination. The argument of counsel for the claimant have been captured in the body of the judgment. So I go straight to the decision of the court. This is the court decision. I have carefully considered the processes filed by the parties in this suit, the evidence adduced at the trial, as well as the written and oral submissions of counsel for the parties. From the facts are disclosed by the pleadings and evidence, the issue calling for resolution is whether the claimant has, by the evidence adduced, proved entitlement to any of the relief sought. I shall, at the risk of repetition, give a resume of the facts for proper appreciation of the dispute before the court. The claimant, Mr. Epion Edem Okon, was an employee of the post University of following enactment of Pension Reform Act 2004, the claimant opened a retirement savings account with the second dependent in respect of contributory pension scheme as provided the claimant's contribution deducted from his salary, and the employee's contribution started in September of 2006 and paid to the second defendant through the third defendant. In this suit contesting validity of his disengagement from service of the first defendant, as at the time claimant was severed, he was 50 years of age. The claimant attained 60 years of age in 2017, thereby qualifying to access his fund in his retirement savings account with the second defendant. According to the claimant, he has made several demands to the second defendant, NLFC Pension Fund Administrators Limited, to access his fund in his retirement savings account for financial sustenance, but to no avail. This was despite the fact that the second defendant has admitted holding the claimant's fund in his retirement savings account, as evidenced by statement of account tendered in evidence before the court. Rather than pay claimant, the second defendant allegedly imposed bureaucratic and unnecessary criteria, frustrating the payment, as the second defendant required documents such as notice of retirement letter, acceptance of retirement from the employer, and a federal government retirement board slip as for Exhibit DW1A for payment processing. The claimant contended that these requirements are impossible to meet because he was severed from employment, not formally retired, as evidenced by Exhibit DW1C. The first defendant defense was that it was not privy to the transaction between the claimant, second defendant, and third defendant, and there was no claim against it by the claimant. The second defendant, on his part, maintained that the claimant is not entitled to the funds in his retirement savings account because he had been refunded his contribution by the Accountant General of the Federation, together with his benefits. Furthermore, he had been placed under the defined benefit pension scheme being maintained and operated by the Pension Transition Arrangement Directorate, PTAD, and he has been enjoying his pension under the new scheme. It was under that scheme. It was also stated that there have been remittances into the claimant's account for 6 years after he had been severed from service, which do not belong to the claimant. The third and fourth defendant did not file defense. This means they have no defense to the claimant's suit. This case seems to have critical questions surrounding an employee's entitlement to pension contributions under the Pension Reforms Act 2004, now 2014, more particularly when there is transition between pension schemes and a severance is involved. There are 5 reliefs being sought by the claimant. The first is for an order of court ordering claimant to pay pension fund in the custody of the defendant to the claimant. The second relief is for an order of payment of the sum of 1,679,000 naira, being the claimant's retirement savings. The third relief is for general damages, 50 million naira. The fourth relief is for declaration, and the fifth relief is for cost of litigation. In civil cases, like the case at hand, the burden of proof by virtue of the provisions of sections 131, 132, and 133 of the Evidence Act 2011 as amended, the initial burden of proof by way of introducing evidence in support of and establishing any facts asserted by a party on the basis on which he seeks judgment or decision from a court of law, otherwise known as evidential burden, lies on the party who made the assertion. The burden in civil cases is not static. and may shift in the course of proceeding depending on the state of the pleading at any particular stage of the case. However, the person making the assertion of facts and who desires a court to give judgment as to any legal right or liability depending on the existence of fact would fail if no evidence at all were given in the case, and so bear the initial burden to prove the existence of those facts asserted. See the case of Akimbade versus Babatunde Woleke versus Goody, Attorney General of Bayelsa and Attorney General of Rivers State, and Agbakoba versus ANEC, and host of other cases cited therein. The law is right that the party that has the primary legal burden to prove existence or non-existence of any fact is the one who desires a court to give judgment. Thus, generally in civil cases, the burden of proof in civil matters is on the shoulders of the person who asserts the affirmative of a particular issue. In the instant case, the claimant who asserted entitlement to payment of pensions, contributions, has the onus of proving such entitlement. If decision of the court is to be given in his favor, to be rendered in his favor, see the case of Aja versus Oboni. Therefore, the burden of proof is on the claimant, who would fail if no evidence is introduced in this case. If he adduces evidence which ought to satisfy the trial court that the facts sought to be proved had been established, the burden will then shift to the defendant against whom judgment would be given if no more evidence were elicited, and so successively until all the issues in dispute as 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 as, as shown by the pleadings of the parties are settled. Like in all civil matters, the claimant is expected to discharge the burden of proof on the balance of probability. See Onye Kanoa versus Kudiri. See Onwubruke versus Segini. This court will be guided in determining this case by the extant rules on the evidence enunciated in the various decisions of courts as cited above. Looking at the 5 reliefs sought by the claimant, I am inclined to agree with the counsel for the second defendant that reliefs 1 and 2 are one and the same thing. In fact, reliefs 1 and 2 are ancillary to relief 4, which is seeking for a declaration that the claimant is entitled to his contributory pension fund as agreed. These 3 reliefs all borders on one thing, i.e. pension contribution. In the circumstances, I shall consider the 3 reliefs together because they overlap each other. The claimant placed reliance in proof of these 3 reliefs under consideration on Exhibit A, B, C, D, E, F, G, H, I, J, and L, K, and L. In relief 4, the claimant is seeking for a declaration. The success or failure of a declaratory relief is dependent on the judicious and judicial exercise of discretion by the court. A discretionary relief will only be granted on the strength of the claimant's case. It will not be granted in default of defense or even in admission. Therefore, this court must be satisfied when all the facts are considered that the claimant is fully entitled to the exercise of court discretion in his favor. He cannot rely on any admission in the defendant's pleading or even a failure to file defense. In the instant case, the claimant sought for a declaration that he is entitled to payment of contribution in his retirement savings account with the second defendant. Therefore, the onus is on him, is on the claimant to prove the entitlement to the payment of contribution in the retirement savings account. He cannot rely on any alleged admission by the second defendant that it had claimant's contribution or funds in his account. See the case of Ladoja versus INEC. See also Odofin versus Ayola. See also Ogolo versus Ogolo. See also Kwajapa versus Bond Limited. And Maja versus Samoris. Alao and Akano. The onus of proof on the claimant is to show that he is entitled as per his claim. He has to succeed on the strength of his case and not on the weakness of the defendant case. And where he defaults in discharging the onus, his case will be dismissed. The claimant is required to plead and prove his claim for declaratory relief on the evidence claimed by him without relying on the evidence called by the defendant. The burden of proof on the claimant is established. Declaratory relief is heavy in the sense that such a declaratory relief is not granted even on admission by the defendant, where the claimant fails to establish his entitlement to the declaration by his own evidence. In the instant case, the claimant stated that he opened retirement savings account. Compulsorily, deductions were made from his salary and remittances to the second and third dependents, who are the pension fund administrators and the pension fund custodians, respectively. However, from the exhibit tendered to support his case, there is no statement of account showing remittances from the date on which his remittances started in to December 2007 when he left service of the fourth dependent. It is also to be noted that the second dependent has averred in the statement of defense that the contribution of the claimant was refunded to him by the Accountant General of the Federation, and the evidence of refund was his payslip attached to his complaint as one of the documents to be relied on at the trial, but the claimant deliberately refused to tender it in evidence. However, the second dependent has, through his witness DW1, tendered the said severance slip in evidence as Exhibit DW1B. The second defendant has also averred that after the claimant had left the service of the first defendant, remittances keep coming into the claimant's retirement savings account, and upon inquiry from Pension Commission, it was stated that the Pension Commission was not informed about the layoff or discharge of the claimant from the service of the fourth defendant. That's why the remittances continued after he had left service. See Exhibit DWE. With the new revelation from the second dependent as per the inquiry made from Pension Commission through the reply, Exhibit DW1E, the claimant chose to remain silent and refuse to offer explanation on the new facts regarding regarding the refund of his contribution, and placing him under the old pension scheme being managed and operated by the Pension Transition Arrangement Directorate. The failure of the claimant to file a reply to the second defendant's statement of defense that raises new issues in a court of law carries significant legal implications. Primarily, this amounts to activating the principles of deemed admission of facts in civil litigation. Pleadings serve to define the issues in dispute between parties, and each party is expected to respond to the abatement of the other. In the case at hand, though there is a need for the claimant to have filed a reply to the statement of defense of the second defendant, it is not mandatory. It becomes crucial when the statement of defense introduces new facts, making allegations or raising new issues that were not contained in the original statement of claim, i.e., refund of claimant's contribution, and placing the claimant on another pension scheme. Placing the claimant on another pension scheme which he is currently enjoying. The primary purpose of a reply in such circumstances is to traverse, deny or contradict, explain or join issues on these new matters. If the statement of defense merely denies claimant's abatement without introducing new facts, a reply may not strictly be necessary. may not be strictly necessary, as the issues would already be joined by the denier. However, as established in the cases of like Ilyasu and Zak like the case in the case of Ilyasu Zaka and others, a reply becomes indispensable when the statement of defense raises new issue or facts in the claim or facts that the claimant wishes to dispute or clarify, as in this case. Therefore, the legal implication of failure to file a reply means the claimant is deemed to have admitted the new facts. The new facts or abatements contained therein in the second dependent statement of defense. The claimant is in law deemed to have admitted all those new assertions that he has been refunded with his contribution by the Accountant General, and he is also currently enjoying his pension under pension transitional arrangement directly. This principle is fundamental to the rules of pleading, which generally stipulate that every allegation of facts in any pleading, if not denied specifically or by necessary implication, or stated to be not admitted, shall be taken to be admitted. The Court of Appeal has consistently upheld the position. For instance, in the case of registered trustees of Living Christ Mission and others versus Aduba and another, the court emphasized the effect of such failure of stating the facts not traversed are deemed to be admitted. The refusal to file reply also amount to loss of opportunity and forfeiture by the claimant to challenge, explain, or contradict the new facts or issues raised by the defendant. See the case of Odera Investment Company Limited versus EcoBank, which highlight the duty of a claimant to respond when new issues of facts not arising from his statement of claim are introduced. The failure of the claimant to file a reply affects the evidential weight and impact of the claimant case. In the circumstances, the court will treat the admitted facts as established and proved. This court will be on the right course to stand by the deemed admitted new facts by the claimant and consider the new facts deemed admitted taken as true and correct. This principle was reiterated in the case of Yaro versus Manu and another, and the case of Ibrahim versus Assad and others, both underscoring the adverse effect of failing to file a reply to a statement of defense. It must also be noted that while a reply is for responding to the defense, it cannot be used by the claimant to introduce new course of action or to depart from the original statement of claim. Its scope is strictly limited to joining issues on the matters raised in the statement of defense. In essence, the claimant's failure to file a reply when new issues are raised in the statement of defense of the second defendant is not a mere procedural oversight, but a substantive omission with severe consequences. It effectively conceded concede the new points raised by the second defendant. Therefore, I consider the new facts on refund of contribution and placing the claimant on new pension scheme as undisputed in this case. Since the court will not make a declaration or grant declaratory reliefs unless such reliefs have been proven by evidence by the party seeking such relief, regardless of whether or not the party on the other side filed evidence. In the instant case, the second defendant's abandonment or refund of contribution to the claimant as evidenced by Exhibit DW1E, which the claimant himself front-loaded but refused to tender it in evidence, has weakened the claims of the claimant seeking for declaration. I am not satisfied that the claimant has, by the strength of his case, proved entitlement to declaration in this case. This finding or relief one or relief four, which is This finding or relief form that the claimant is not entitled to declaration means also the failure of relief one, which is an ancillary claim dependent on grant of relief four. In the circumstances, I hereby dismiss reliefs 4 and 1 due to lack of proof. I now turn to relief 2, which is for an order directing the defendant to pay claimant the sum of 1,670,000 being the contribution as evidenced by the statement of account which claimant alleged were sent to him by the second defendant. Let me make it very clear that a claim for payment of pension contribution being monetary in nature is generally considered a claim for special damages. Special damages are those losses that are quantifiable, ascertainable, and directly attributable to the breach of contract or duty, unlike general damages, which are presumed to flow from the wrong and are left to the discretion of the court. Special damages must be specially pleaded and strictly proved by the claimant. The classification and principle governing special damages are primarily established and reinforced by judicial pronouncements from superior courts, particularly the Court of Appeal and the Supreme Court. These courts consistently hold that any claim for a specific quantifiable financial loss must be treated as special damages. See the case of NECA BB Manufacturing Company Limited versus ACB Limited. See also Arison's Trading and Engineering Company Limited versus Military Governor of Ogun State. Both emphasize the duty on the claimant who claims special damages to prove it strictly. These cases establish the fundamental principle that special damages are not awarded on mere conjecture but on concrete evidence. See also GTB PLC versus Mobecom Technologies Limited, which provides guidance on how to plead and prove special damages, reiterating the necessity for specific pleading and strict proof. The case of Ogojiefo versus Ubaka Son Nigeria Limited further clarifies the instances at which a claimant is said to have discharged the onus of proving special damages, reinforcing the high standard of proof required for a claimant to prove for the claimant to prove a claim for unpaid pension contribution, as with any other claim for special damages, require meticulous attention to pleadings and evidence. The claimant must satisfy the court on two main fronts: the entitlement to the contribution and the exact amount due. This means the claimant must specifically plead the claim for unpaid pension contribution in a statement of fact. This involves stating the precise amount claimed and providing the particulars of how that amount is arrived at. For instance, the claimant should specify the period for contributions were made, the monthly or annual salary on which the contributions were to be based, and the applicable percentage rate contribution. Failure to specifically plead special damages will result in court not awarding them even if there is evidence to support the claim, as held in the GT Bank PLC versus Melbourne Technology Supra. The burden of proof lies squarely on the claimant. He must adduce credible and cogent evidence to substantiate every item of the special damages claim. This typically involves documentary evidence such as pension contribution payslips showing deductions or lack of deductions thereof for pension, statements from the pension fund administrator PFP indicating contribution received. If the claim involves interest, the basis of calculating such interest must also be provided. The claimant is also to give oral testimony to explain the documents and the circumstances surrounding the payment. The claimant must present a clear calculation of the total amount owed. This is not merely stating a figure, but demonstrating how the figure was derived at. For example, if the contribution rate is 8% of basic salary, housing and transport allowances, the claimant must show the monthly sums of these components and the 8% calculation for each month for each month of the contribution. The strict proof for special damages means that the evidence must be direct, specific, and leave no room for speculation, as established in NECA Manufacturing Sufra, Addison Trading versus Military Governor of Ogun, also Sufra. The claimant must prove not only that he suffered the loss, but also the exact amount that he lost. If, if the evidence presented is clear, cogent, and unchallenged by the claimant, the court unchallenged by unchallenged by the defendant, the court will accept it as sufficient proof. The claim the claim by the claimant of his contribution due to refusal of the claimant to pay him after several demands represent a specific financial loss that can be precisely calculated. According to the claimant, he was severed from his employment with the fourth defendant. He also stated that his contribution started with the deductions from his salary from his September 2006 salary. He also maintained that the money in his retirement savings account with the second dependent were from deduction from his salary. The evidence of the claimant has made it clear that the money he is requesting in the sum of 1,679,000 naira is the amount deducted from his salary and paid into his retirement savings account for him to access upon attainment of retirement age of 50 years of age. From the pleadings and evidence, there is no particularization of the quantum being claimed by the claimant. The law is settled. Without particularization, special damages will not be granted. Even where there is particularization, the claimant has the onerous responsibility of strict proof of his conduct. This can be done by making available or amount being claimed. In the case at hand, the evidence being relied by the claimant in proof are Exhibit G, H, I, and J. I have scrutinized this exhibit. It is clear to me they are not capable of proving the claim of the sum of 1,679,000 naira as the claimant contribution deducted from September 2006 to 31st day of December 2003 when he was disengaged from service. The second defendant has also disputed the claim in that it was about that the claimant has been paid his contribution by the Accountant General of the Federation alongside his severance entitlement, and thereafter he was placed on another pension scheme. I have considered this issue here in before and came to the conclusion that the failure of the claimant to reply to the issue amount to admission. I adopt my finding and reasoning above on this issue. Let me also say that Exhibit H, which the claimant heavily relied, cannot be accorded any weight due to the fact that the document had mixtures of other documents belonging to one Mr. Godwin Amanam of 12th Answer, Ewa Lane of Hawkins Road, Calabar. Furthermore, in Exhibit H, the contribution shown started from 2011 and not from September 2006 when claimant started making contribution. The claimant did not also speak to the exhibits. It was dumped on the court. Furthermore, the pages are not eligible. Also, in some of the statements, they did not show the name of the owner of the statement of account. I am of the view that the claimant deliberately modeled Exhibit H so as to create confusion and deceive the court in granting him his claim without proper proof. However, his plan failed as this court would not allow itself to be deceived by the antics of the claimant. The claimant, in this case, having had his contribution refunded by the Accountant General of the Federation and subsequently transferred to the pension scheme operated by the Pension Transition Arrangement Directorate, will generally not be entitled to claim his contribution from his pension fund administrator upon attaining 60 years of age. This conclusion is based on the fundamental principles of contributory pension scheme (CPS) as established by Pension Reform Act and the implication of a reform. Under the Pension Reform Act, every employee in the public service, with certain exceptions, is required to offer retirement savings account with PFA, into which contributions are made. Section 16, subsection 1 of the Act stipulates that an employee shall not be entitled to make any withdrawal from their retirement savings account before attaining the age of 50 years. However, Section 16.2 provides an exception allowing withdrawal if the employee retires, disengaged, or is disengaged from employment. In the case at hand, the claimant was laid off at 50 years of age, which falls under the disengaged from employment category, potentially making him eligible for withdrawal at that point. However, he did not make any withdrawal at 50 years of age, and now he has reached 60 years of age, and his contributions were refunded to him by Accountant General of the Federation, and that he was transferred to another pension scheme being operated by the Pension Transition Arrangement Directorate. With the refund of the contribution to the claimant, there is nothing left for the claimant to access, as Exhibit DW1E has directed transfer of the fund into the pension account maintained by the Pension Commission. The transfer of the claimants to another pension claim, which he did not dispute, means that he cannot enjoy two benefits for one service. When an employee is transferred to PTDA managed scheme, it implies a shift from the contributory-based system to a benefit-based system, where pension entitlement are calculated based on factors like years of service, the last emolument, rather than balance in an individual retirement savings account. Therefore, the refund by the Accountant General of the coupled with the transfer to PTDA strongly indicate a final settlement of the employee's entitlement under the contributory pension scheme. Any subsequent pension claim would then be governed by the rules and the regulations of the PTDA scheme to which the employee was transferred, and not from PFA under the PRA under the Pension Retirement Act, under Pension Reform Act. The claimant cannot claim contribution from PFA because those contributions have already been refunded to the Accountant General of the Federation. The claimant's pension entitlement, if any, would now be administered under the Pension Transition Arrangement Scheme, subject to its specific rules and the employee's service history within that framework. It is also my view that even if the funds, the sum of 1,679,000 naira are still in the accounts of the claimant cannot claim refund of such money from the second dependent, because it will be against the Pension Reform Act to refund such a money to a discharged employee. All that can be done is to use the guidelines of PENCOM in accessing those payments, and not through refund, direct refund to the claimant. It has to be as provided in the guideline. It is meant for pension, and it has to be programmed for pension if the claimant has to benefit from such an amount. In view of the foregoing, Relief 2 also failed, same is hereby dismissed. Relief 3 and 5 are for injury suffered and cost. There is no evidence of any injury suffered by the claimant. Relief 3 failed due to lack of proof. It is hereby also dismissed. Likewise, Relief 5 is at the discretion of the court. Having regard to the circumstances of this case, I award no cost parties to bear their respective court. On the whole, the claimant willfully failed to establish entitlement to any of the relief sought. The case of the claimant failed, and same is hereby dismissed. Yes, Registrar. Registrar. Okay, thank you, Counsel. We have come to the end of today's virtual sitting. You are free to leave the sitting.
My lord.
Okay. Registrar, what is happening?
My lord, the next one is tomorrow. Yes,
You said?
we have another one tomorrow, my lord. But this one is all for today.
Okay, thank you. We have come to the end of sitting. Have
Thank
a
you, my
nice
lord.
day. Okay.
Thank you, my lord.
Okay.
And you too, my lord. Thank you, my lord.
Mhm.